Hello, Colorado Realtors. I'm Scott Peterson. Thank you for joining me for another long overdue edition of Legal Bites. First of all, I want to apologize. I've been out, tanning and enjoying the sunshine all summer long, and realized that I've neglected for a pretty long period here to produce any of these new Legal Bites, and I know that's left many of you just hanging by the edge of your seat, hitting refresh on your YouTube video channel to see when one pop up, and so my apologies. Of course, I wasn't tanning and hanging out at a beach all summer. I was busy, so I do apologize. But here we are with another edition of Legal Bites, and thank you guys for joining me. Today we're going to talk about the new closing instructions that came out, and I know there has been a buzz in the real estate market all summer long. I felt it, and it hasn't had to do with market activity or velocity or interest rates or anything else. It's had to do with the brand new closing instructions that came out right in the middle of the year, and they became effective in this case July 1st of 2019. So at this point, they're mandatory for you to be using in the event that you are using them, and I'm hoping that I can prevail upon you to use them, and I'll get back to that in just a second. But the new closing instructions came out and are now effective and mandatory to be used July 1st, 2019. And there were some changes that were made. They got longer. Sorry about that. But they're good changes that I think in many respects benefit you. The biggest, I believe, substantive change that occurred was that we removed the scrivener's authorization from the old closing instructions. That came out. And so now there's no more scrivener's authorization. Well, what does that mean? That change was mandated by House Bill 1098, which was the deeds bill update, and which is the other reason that you got a brand new contract again, where there were modifications made to paragraph 13 of that contract based on some statutory changes that were made by the state legislature this last spring. And one of the things that bill did was it gave title companies the authorization to prepare deeds, which they didn't have before. Only you had that authorization, and that's why you had to give the title company your scrivener's authorization to prepare the deed effectively on your behalf. Well, that's no longer the case, because now title companies can prepare the deed on their own behalf through their own statutory authorization that they received, which is a good thing, again, because it keeps a broker who's not preparing the deed out of the liability chain for any deficiencies or inaccuracies or anything else that might be on the deed. So as long as you're not preparing the deed and you're using the new closing instructions, then there's no more title company doing it on your behalf as your scrivener, because the scrivener's authorization is gone. That's the biggest single change. There's also some additional language with regard now to the instructing the closing company or title company to prepare the deed with regard to deed preparation and how that's done, as well as some additional language regarding the preparation of a bill of sale, and that would be in connection with any conveyance of personal property that might be included as part of the real estate transaction. So those are the changes that occurred and why you got a new form. Here's my teaching point, or what I want you to take away from this. I think the brokerage community has gotten lazy as it comes to preparing closing instructions as a whole. And I think that's really what it amounts to, because it's not difficult to prepare the closing instructions. Most form software sort of auto-populate the whole form based on the contract. Use the CREC approved form. Use the new form that you've been delivered, and do it at the time of contract, and deliver it in connection with the contract to the title company, and have them sign it. And just don't be lazy to do it. I think that we occasionally get in, and I get this a lot, questions from brokers around the state or realtors around the state who get into this conflict with the title company. And either A, because the brokers aren't doing it at the time of closing, so in that case, the title company is preparing closing instructions, and those are done at the time, or executed generally at the time of closing, versus a broker who needs to do it at the time of contract. So I get into these questions about conflicts. And so if a broker is preparing closing instructions and delivering them at the time of the contract, as I believe they should be, and the title company then is preparing additional closing instructions at the time of the closing, then it creates this conflict that really you shouldn't have two closing instructions. You need one set of closing instructions. The broker ought to be doing it and delivering it at the time of contract, and that's it. Those are already signed. That's what's done. Those are what control the closing process. And I don't believe that parties ought to be signing a second set of closing instructions at the time of the closing itself, that are the title company's form. You ought to be confident and comfortable in declining on behalf of your client or advising your client to decline to sign additional sets of closing instructions. You never want conflicting legal documents, and if you have two sets of closing instructions, I'm not even sure which one controls in that case. So don't be lazy. If you're a broker, it's very easy to do. Do the closing instructions, use the CREC approved form, the Colorado Commission approved form, at the new one, at the time of the contract. Get that executed by the parties and the title company. Get that done then, and then feel comfortable in saying, listen, we've done our closing instructions. We don't need another set of closing instructions that are title company prepared closing instructions. Okay? So one set only. That's my practice advice to you. Couple of events that are coming up. We've got the National Real Estate and Cannabis Summit. That sounds fun. Don't miss that one. I don't know what's going to happen at that Wild Wild West show. And then, of course, our fall forum that's coming up a little bit later in October. So thank you for joining me for another edition of Legal Bites. As always, if you have questions about any of this stuff, the legal hotline is available for you. And we will see you on the next edition of Legal Bites. I'm gonna record one right after this, so I'll be in the same outfit, but it won't be so long before you get your next Legal Bites from me. Thanks so much. We'll see you next time.